Okay.
I'd like to bring the November 28th, 2017 meeting of the Complaint Committee of the Sunshine Ordinance Task Force to order. Please call the roll.
I'm going to call the roll. Member Wolf.
Here.
Wolf present. Member Hensey.
Present.
Hensey present. Chair Tesfa.
Present.
Tesfa present. We have a quorum.
Thank you. If you could call the next item.
There are no agenda changes that I know of, except for the item 4 where there's a request for postponement, but we can deal with that when we get to it. Next on the agenda, item number 2, approval of the October 24th Complaint Committee meeting minutes.
Do we have a motion?
Move to approve the minutes.
Second.
Do we have any public comment on that motion? Seeing none, can we take that by acclamation?
That motion is passed without objection.
Thank you.
Next on the agenda is item number 3, public comment. Members of the public may address the committee on matters are within the committee's jurisdiction but not on today's agenda.
Do we have any public comment? Seeing none, public comment is closed.
Next on the agenda is item number 4, file number 17118, complaint filed by James Stark against Supervisor Aaron Peskin for allegedly violating Administrative Code Section 67.21 by failing to respond to a request for public records in a timely and/or complete manner.
Is the petitioner present?
I did receive a phone call from Mr. Stark stating that he wished to postpone the matter.
Thank you. I did look at the item that was in the packet, and I thought that these items were public and that we have jurisdiction over this matter. Do the other members have any discussion on this or a motion to find the items public, the documents public, and for us to have jurisdiction over this matter?
So moved.
Second.
Is there any public comment on that motion? Seeing none, can we take that by acclamation? And then now if we could entertain the request for this item to be continued. Is there any...
Move to continue the item.
Second.
Is there any motion on the continuance of this item?
Just made the motion. Any public
Oh,
comment?
sorry. Do we have any public comment on this item? Seeing no public comment on this motion, can we take it by acclamation?
Yes, that motion to continue is adopted without objection.
Thank you.
Next on the agenda is item number 5, file number 17117, complaint filed by Patrick Roddy against the Department of Public Health for allegedly violating Administrative Code Section 67.21 by failing to respond to a public records request in a timely and/or complete manner. Just a little bit of history on this matter. There was a complaint previously filed where the wrong subject matter was, they were discussing the wrong subject matter, so we opened a new file and brought it back today for discussion.
Thank you. We are now, we have moved to item number 5 on the agenda. Item number 4 has been continued.
Mr. Hefner was here for the previous item. He is with Aaron Peskin's office. I don't know if you want to, if Mr. Hefner has any comments.
As a summary, we have found these items to be public and within our jurisdiction. The item has been continued per the request of the petitioner till the next meeting.
May I address the body?
Victor, do you have anything to say? You're about to say something.
It's just I'm not sure if this will be at the next meeting, as Mr. Stark is a little bit difficult to work with, and
Okay.
I haven't decided to be able to pick a date with him yet.
Okay. Would the other members like to give an opportunity for the representative? Okay. You may approach. Maybe give him 2 minutes to make a few comments.
Hi, thank you, task force members. I believe this is the Complaints Committee, Chair Tesfaye. Thank you for having us. Lee Hepner on behalf of Supervisor Peskin. Just a few quick comments on this. This was a request that was made to our office on Friday, October 27th, 3 days before the complaint was filed against our office for failure to respond. For that reason, I was coming prepared to argue that you do not have jurisdiction to hear this because because your jurisdiction is not yet vested. This is rather this is a records request, properly deemed a records request rather than a complaint for failure to respond to a records request. I have been in communications with Mr. Stark. I communicated with him again today. The record that he requested does not exist, but a related not responsive record does exist that I am mailing to him, and that is all I really have to say, except for the fact that I also learned very late in the day today that this matter had been requested for continuance. I don't know when that continuance was requested. Our office was certainly never apprised of the request for continuance, or I would be doing other facets of my job right now, to be frank. So respectfully, I request that you find that you do not have jurisdiction to hear this complaint and file the matter. Thank you.
So we've already voted on this motion. My request would be for Victor to be in touch with the petitioner to see if he could withdraw this item, because it sounds like it's being resolved with Supervisor Peskin's office, and if not, we will give notice to both parties of when it's been rescheduled. Do we have any discussion from the members?
Are you asking for the motion to be rescinded?
I'm not.
Okay.
Okay. So Victor, please be in touch with the petitioner. If their request has been fulfilled, ask them to withdraw their item. If not, we can just reschedule this for the next available time that you can find.
Yes.
Thank you.
Item 5 has been called.
Can the petitioner please approach?
Hello, hi. Again, I'm Patrick Roddy. First of all, I want to thank everybody involved in this. It has been resolved. The original subject that got brought up at the last meeting, I was asking for how many people died on each of those dates. And when you said from the chair, there's a public record, this needs to be released, I then submitted a more detailed one asking for more demographic information like cause of death and all that kind of stuff. And I submitted that, and the Public Health Department did respond. It is a voluminous request. The state system is kind of clunky, but they said they will actually provide that. So this is going to be awesome. This is going to be very important research, I believe. And I want to thank both Stephanie and Linda here for helping me. They're asking for a continuance to give them extra time, so they'll get it to me by December 11th, which is fantastic. And I just want to thank everyone involved. So the one being considered right now doesn't need to go ahead. If they aren't able to make December 11th, I'll be in contact with them, and if there's any other trouble, I can come back here. But I want to thank everyone for their help. So yay.
Thank you. Would you like to withdraw your item?
I'll withdraw. Thank you.
Thank you. Members, is there a motion?
As a withdrawal, there's no need for a motion.
Wonderful. Thank you.
Thank you.
Just acknowledge it.
Yes, we are acknowledging that you wish to withdraw your complaint, and this matter will be closed.
Thank you.
Thank you. Before we move to the next item, I know that we had some technical things we were trying to work out with the volume for item number 6. Do you know if any of that's been resolved?
Yes.
Or do you want a recess to
Jessica,
check?
would you like to test our line? Ms. Bloom, are you on the line?
Oh, sorry. Yes, I was on mute. Can you hear me?
No, it's really low.
Would you mind speaking a little bit louder? We're having a little bit of a problem.
Yeah, let me switch to headphones.
Yes, give me a moment. I'll try to call downstairs.
Okay, does this work? Does this sound better?
It's still a little bit low on our side. We will try to adjust that before we move forward. Give us a moment.
I'd like to call for a 5-minute recess so that you have some time to make the call. Thank you.
Hi, David. It's Victor. We're still having problems.
We will resume this meeting. Please call item number 6.
Item number 6, file number 17121, hearing Ethics Commission's draft enforcement regulation and enforcement of order of determinations by the Sunshine Ordinance Task Force.
And I believe that we have a presentation on this item.
Yes, we have Jessica Bloom from the Ethics Commission on the line to make her presentation regarding the matter.
Deputy Director.
Thank you. And how many minutes will we have been listed to provide for Ms. Bloom, or how long will this presentation be?
Ms. Bloom, how much time do you believe you need to make your initial presentation?
Oh, maybe 5 minutes. It's mostly an opportunity for us to discuss some proposed changes and for you all to ask questions about the regulations. That should be a part of your packet.
Okay, thank you. And does everyone have those documents?
Yeah, it's in the.
Okay.
I do have extra copies if you would like it.
Okay. It looks like we all have copies. Thank you so much, Victor. Please begin, Ms. Bloom.
Sure. Thank you very much. My name is Jessica Bloom. I'm Deputy Director of the Enforcement Division at the Ethics Commission. For the past year, I've been evaluating our enforcement regulations, both our general enforcement regulations and the regulations for handling referrals from the Sunshine Ordinance Task Force, to try and see if there's a way that we could marry the two documents so that there isn't a confusing dichotomy for enforcing Sunshine Ordinance Task Force referrals, and to make it easier for the public to understand what's going to happen and what can be expected when something is referred to the Sunshine Ordinance Task Force. I've also really taken care to think through ways that we can better ensure that the Ethics Commission will actually enforce referrals from the Sunshine Ordinance Task Force. I fully acknowledge, I think it'd be insincere if I didn't, that our commission doesn't have a very good record in the past of actually enforcing the law when they receive a referral from the Sunshine Ordinance Task Force, and I want to change that. So if you should have the enforcement regulations, the draft regulations in front of you. There will still be a few tweaks to these regulations before they become public, and then before they're adopted by our commission. And certainly I would open the opportunity for this body to provide public comment or written comment in any way, or verbal comment to me here in this meeting regarding the ideas that I set forth in these regulations. But just generally, I'll walk through the new ideas that I'm trying to incorporate into the regulations. So as the Sunshine Ordinance Task Force knows, there are two areas under the Sunshine Ordinance where the Ethics Commission sort of comes into play. The first is if there's an allegation of a willful violation of the Sunshine Ordinance by an elected official or a department head, and the law says that the Ethics Commission shall handle those violations. In the past, under the previous regulations, we did that pursuant to a separate set of regs. And going forward, I'd like us to handle those investigations just in the normal course of business under our regular enforcement regulations process. They, too, don't differ that much. In fact, I'm not sure that they differ in any way. It's just that, for some reason, we decided in the past to put them in a different document. So going forward, they will, all of the allegations of willful violations of the Sunshine Ordinance, of the Sunshine Ordinance by elected officials or department heads will be handled by the Ethics Commission pursuant to this general regulatory structure that you see here, sections 1 through 9 and then 11 through 13. You can, if you turn to page, let's see if I can get it, 17 of the draft regulations in front of you and look at section 10.
Hold on a minute. That is page 17 in the lower right-hand corner of the page, not the agenda page number in the middle.
Thank you.
Okay. Continue.
Yes. So on page 17 of the draft regulations, section 10A is where I identify the fact that that unique set of violations that will be handled by the Ethics Commission will be handled pursuant to these draft regulations. And then section B is where I start discussing how we will handle referrals from the Sunshine Ordinance Task Force. Now, here, I started out by just simply copying and pasting the structure from the current regulations. So you would be somewhat familiar with how the process works because it's very similar to the way it works now, except I've added a few safeguards. The first is we will still have a show cause hearing upon receipt of a referral from the Sunshine Ordinance Task Force, but we don't limit ourselves to holding a show cause hearing to circumstances that involve like willful violations by city employees or any of the other circumstances that were identified previously in our Sunshine Ordinance regulations. In other words, when this body decides that a violation of the law has been committed, any kind of violation of the law, whether a willful, non-willful, city employee, city official, and you want the law to be enforced, you just refer it to us, and we will handle the show cause hearing as contemplated by the statute. By the ordinance. That is new because we used to limit ourselves to certain circumstances, types of referrals, and I sincerely do not want to limit your body in any way in terms of what it can send to us. And that is because if you look at Section 6730 sub C of the Sunshine Ordinance, I'll just read that out to you. It states in relevant part, the task force shall make referrals to a municipal office with enforcement power under this ordinance or the California Public Records Act or the Brown Act whenever it concludes that any person has violated any provision of this ordinance or the act. So the prior regulations limited the type of referral you could send to us, but the Sunshine Ordinance itself does not. And so my goal was to make the regulations match the ordinance and give you the opportunity to refer all cases to us that you feel need to be enforced. The next new item would be that if you'll look at the standard of review under subsection 2.
Can I interrupt you for just a second before you move on
please.
to the next item?
Yeah.
Just want to make sure that everybody's understands what she is pointing out and how this will, kind of change things. Okay, thanks. Yeah, if there's something, 'cause I know she's just going to rattle it all off, right, Jessica? And, then we'll pick it up later. We just want to make sure point by point we get some delineation between the points. That's all. Thanks.
Yeah, sure, of course. And I can take questions point by point if that's how you'd prefer.
And Jessica, just to let you know, I've arrived at the hearing.
Oh, wonderful. Great. And Jeff's there too. So thank you, Jeff. This is Jeff Pierce. He's a senior investigator and legal analyst in our office. He's a California attorney, and he's been working with me on these regulations.
Great. Thank you for being here. Continue.
So the next big change is that the commission under subsection 2 will now defer to the findings of fact set forth in the Sunshine Ordinance Task Force's order of determination. However, any party may bring evidence to present or witnesses to testify on their behalf at the show cause hearing, and then of course the commission will continue to review conclusions of law independently, which is how it operates now, simply because the commission has the authority to interpret the law and promulgate regulations. So the big change there is that we'll be deferring to findings of fact set forth in the Sunshine Ordinance. Later on, under hearing procedures, I added a provision for newly discovered evidence after talking with Chair Wolf, actually, that says if any party that presents evidence to the commission, as I just mentioned, during the show cause hearing, if any of that evidence is new and the Ethics Commission doesn't want to make a determination based on that, the Sunshine Ordinance Task Force's order, in light of this new evidence, then the Ethics Commission will now have the opportunity to remand the issue back to the task force for it to conduct the further findings of fact into the new evidence and for it to decide whether or not it still thinks there's a violation. That's an option that the commission will have. They don't have to do that. But I think it will really help in circumstances where, for example, you have had a scenario where no respondent has showed up I think a very good example of this is the recent Steve Cava matter, where Steve Cava never appeared before the Sunshine Ordinance Task Force, but he came to the Ethics Commission. And in that case, my view, I would have recommended to my commission, if we had the option, would have been to remand it to you for further consideration of Mr. Cava's testimony, because it turned out to be, relevant and pretty dispositive for the Ethics Commission.
Let me can we just have an open discussion? Is that right? Great. Just asking the chair for permission to have open discussion. So I just want to say that on this point, I think the concern that I have with this, I think it's good. I like the idea of all this. My concern is that sometimes cases get complicated, and if the Ethics Commission wanted to tackle it, you might be going, through a considerable amount of time trying to understand whatever complications that the task force has already gotten through. And because it may have gone through a number of different hearings, it could have gone through a number of different hearings at the committee level, so on and so forth. I'm just saying that I think the task force would feel a little you just feel like they should have the opportunity to continue with the adjudication. For you, it would be the show cause part of it. When a case is that complicated, if it's really clear cut, and there's something new that comes up, and it lends to something that's very understandable, I get that. But I get a little concerned about another body having to, open up a whole case all over again from the beginning. Just so that they can get to understand it, when it could easily be referred back to the task force.
Yeah, I think that we would never open up a whole case again so that we could understand it. I think you're right that is not something that we would want to be involved in, which is why the remand option is an attractive solution to that. So if something comes up that sounds like it might be something that would have affected your decision, we wouldn't go through the exercise of determining whether or not it affects the decision. We would just send it back because you guys have the history and the record before you, and you could make the decision. You're better situated to determine whether that newly discovered or new evidence is important or not. And if it's not, then it comes back over to us, and we proceed as normal. And if it is, and you change your mind, or you send a slightly different referral to us, that's another thing too. But we want to create an opportunity for us to send the issue back to the body that already did the deliberation, so that we don't have to re-investigate everything.
I also hope, this is Chair testified, that the Ethics Commission will be very willing to use this remand option consistently, so that parties will be aware that when this type of issue comes before the task force, they need to take it seriously before it's elevated to the Ethics Commission, so that they appear prepared before the task force, and that new evidence isn't showing up months later once it gets to the Ethics Commission, because in all likelihood the evidence, I'm sure it existed prior to it being elevated to the Ethics Commission, and for the party to get their ducks in a row and produce that evidence at such a late date is very troubling. I'm sure it's happened, and I'd rather parties be aware that the Ethics Commission will be remanding their case, and that the Ethics Commission will consistently do so to show that parties that are in this situation of a show cause hearing will have already presented everything that they had at the time of their appearance at the task force.
Yes, again, I agree. I agree completely. I think that this provision will create a clear delineation between the two bodies, so that factual determinations are being sent to the task force, and then the legal conclusions and the meting out of enforcement penalties is from the Ethics Commission, and people aren't ignoring your body because they know they can come to my body and change their minds at the last minute. I think we definitely agree that that's a waste of time, and we want to strengthen both bodies' roles here so that it's very clear that people need to start responding and taking seriously what's happening at the Sunshine Ordinance Task Force, because it will end up over at the Ethics Commission, and that entire goal, I think, is really met by the last and very most significant, in my view, change, which would be to incorporate the Ethics Commission's charter penalty authority, and that's under subsection V. And the charter gives the Ethics Commission authority to impose administrative penalties of $5,000 per violation, or cease and desist, and require the filing of missing records or reports. Under our regulations that we have right now, for some reason we decided to not give ourselves authority to institute penalties. And that, I think, has resulted in some absurd results, because what we see is our commission is having to choose between the only penalty that's articulated in the current regulations, which is a finding of official misconduct, and no penalties. And when faced with those two options, they always choose no penalties. They always choose not to find a violation. So I want to put more tools in their toolbox so that they can, if they're looking at a case and you are referring something to us where you think there's been a clear violation of law, and there has been, like, for example, with most recently with Eric Marr, who had not produced Mr. Hartz's records for a number of months, that was a clear violation. Our commission wasn't willing to find official misconduct because it would require them to send a letter to the mayor instituting removal proceedings. But they might have been willing to fine Eric Marr $5,000. And so giving our commission an additional remedy option, I think, will certainly help increase the likelihood that the law is enforced. And we've checked with the city attorney on this, and he agrees that we have the authority to do this. And so we've incorporated it into these regulations.
Jessica, I have a question with regards to two things. One is, and they're kind of related. One is with regards to what you just explained around the 6734 willful failure part. It's interesting to say that if they don't want to initiate penalties, that they will not find in violation, and that's been the crux of the biggest problem, because we find then that puts the Ethics Commission in conflict with the Sunshine Task Force. We have found that there is in fact a violation, and that if they don't want to issue penalties, and the only way they can do that is by not finding violation, that kind of defeats kind of the whole purpose, and then it's like, who's right then? So my concern about that is, why not just stick with the enforcement part and say, at this time we choose not to initiate enforcement? It doesn't then nullify that a violation is in fact apparent, and it doesn't subvert or undermine the work of the Sunshine Task Force and its legal counsel. I think that's really important, considering we're kind of a community body that is all appointed by the Board of Supervisors, not the mayor, and not by any other elected official. While the Ethics Commission has one member that is elected by the Board of Supervisors independently of all the others. And so it's a little bit different makeup. The status and the respect may be different, be carried different. And that's one thing that the Sunshine Task Force has had difficulties with, because it hears complaints. It's one of the few bodies like yours and the Board of Appeals that hears complaints from the public, and is not just a legislative process or some other kind of type of body. So I think it's in order to preserve the work and the findings of the task force, that I'm wondering if there may be some way to kind of reword it in that way, because now moving into your proposal here, let's see, it's where did I see this? standard of proof. I'm looking in section 10B1. So deliberation and findings under subsection Roman numeral 4, small Roman numeral 4. So in the middle, it says the commission will consider all the relevant circumstances surrounding a case. The finding that a respondent committed a violation of the Sunshine Ordinance will be supported by the facts and findings of law based on the entire record of proceeding. I guess, wait a second, let's see. So it would be in letter C, paragraph C, final decision, a dismissal or closure of the complaint after notification to the commission pursuant to this section. I'm a little concerned about that because, we want to we want to again preserve all the work and the kind of.
Yeah, no, I think that's right, Bruce. I think that's actually a mistake that it's worded that way. So I'm going to flag that for myself to fix it.
Okay.
So that should say a decision, an enforcement decision by the San Francisco Ethics Commission is a final decision.
Right. So
not a closure or dismissal. We won't close or dismiss anything that you send us. There wouldn't be a closure or a dismissal. There will always be a hearing.
Right. Because one of the things is if people who have gone to district court and they try to and they take up a case on violation of the Brown Act or the CPRA, they will ask, have you exercised the local process? And the task force is a local process. So if we found in violation, and then if you nullify it, if the ethics commission nullifies it, then that it kind of subverts or undermines that process, because a person can not. We could not send it for enforcement, and then it would still be valid as a viable finding in a court, and then there'd be no. I'm concerned that there could be some. For instance, if we find a violation and then you decide not to provide enforcement on that violation for some reason, and then that goes to court, how does that best serve the law and the public, the best interests of the people? I'm just looking at future thinking, potential issues in process.
Yeah, and I agree again. I think that a court would probably actually refer a Sunshine Ordinance. Like if somebody, I think it's an open question whether your orders of determination can be, I guess it'd be like a writ. I think that because they have no, they don't impose any penalties on anybody, they'd have to go to the Ethics Commission and then have something in their hand before they could say their legal rights were affected in any way. But that aside, I agree with what you're saying, that we need to make sure the Sunshine Ordinance Task Force process is respected and that their orders are not just dismissed out of hand, and that if there's a dispute among the agencies regarding a provision of law, that we can work through that in some other way. And that is sort of, aside from these regulations, is something that you and I had talked about previously, and that is that the Ethics Commission has regulatory authority under the Sunshine Ordinance. And I don't see any reason why we couldn't work together to come up with some rules or regulations that interpret the Sunshine Ordinance, some of the more confusing provisions, so that there is something binding on our agency that you can point to or turn to when you're calling the balls and strikes during your hearings. That would require us to be bound by that. The recent example that most concerned me was the Angela Calvillo order of determination, Ray Hart's order of determination against Angela Calvillo for the minutes. addendum issue, and that it appeared both of our bodies had got back and forth on the issue a couple of times, and that's just simply unacceptable because the government doesn't have any way to know if your body says it's one way and our body says it's another way, that means we need to get together and promulgate a regulation that explains. That means that something is confusing in the law, and we need to get together and promulgate a regulation that explains both of our agencies' view that's binding on both of our agencies. And so, this is our first step, these enforcement regulations, to sort of make it more likely that our office will enforce the law, my commission will enforce the law. The next step is to put our heads together and brainstorm areas where we need to start clarifying the law as well.
Can I jump in?
Sure.
Sir, can you introduce yourself for the record?
I'm Jeff Pierce. I'm a senior investigator and legal analyst with the Ethics Commission. I'm just here to try to help field questions, particularly if Jessica loses her voice at any point. But Jess, I don't want to cloud the conversation, but I am trying to understand Mr. Wolf's concern. And if I hear you saying, Mr. Wolf, that you hope that your orders of determination might be binding on future entities who consider the same set of facts and law, I think the answer has to be no. An agency that enforces its own, an agency that exercises its own enforcement powers has to be satisfied that it's doing so with cause, whether that's the Ethics Commission or the Superior Court of the County of San Francisco. And I would just point to the ordinance where in 67.35C, the ordinance provides that a court might find that an action filed under this section was frivolous. And so there could be, this may be implausible, but there could be a citizen who files an action in Superior Court seeking enforcement of their matter, because the ordinance allows that someone could seek enforcement not only through us but through civil litigation. But the court still has an opportunity to determine that the action itself was frivolous. That doesn't decide the issue, but it suggests that the court, like our body, I think, will have to satisfy itself that if it's going to exercise its enforcement powers, it's going to want to be certain of the facts in the law. And the way that Jessica built the regulations, deferring to the factual findings of your body is similar to how any appellate process might work, where the entity who takes the first crack at the evidence is typically considered the fact finder. And you would base your determination on your findings of fact, and then you would apply the law to those facts that you found. But a court would have to review the body of evidence just to make sure that there were no clear errors, and then for its own self apply the law newly to the same set of facts that you had found. And in many cases, they will agree with you. But they have to retain the option to disagree with you because it's their enforcement power that they'll exercise.
Okay. I understand what you're saying. I think my concern is survivability.
Okay.
And without subordinating the task force. Because the way it's at least with 6734, the way it's been interpreted for all the years that I've been on this body. I've been on and off this body since 2005. So there's been some consistency that there's a bright line for enforcement, and there not be a re-adjudication of the entire case to determine that. And so it would be, because there are other bodies or departments that could also provide the same enforcement, which would be the Attorney General or the DA. Now, how would they go about, would they re-adjudicate it themselves? I mean, the purpose in the ordinance is specific for enforcement. Now, that doesn't say that they should determine the facts as to whether enforcement is warranted or not. The point is the violation has been found. Determine what the enforcement should be. Should there be, enforcement without penalty, a slap on the wrist, don't do this again, or, take them for every dollar that they got. And that's been kind of the bright line that, and it's not been challenged. That's why, we have some history here on this, and there's been less history on sunshine at the Ethics Commission with regards to adjudicating sunshine cases there. So that's what I want to be careful about. That's why I'm kind of bringing this up, to make sure that that there is some survivability for what we have found, because we also have legal counsel here, and they're going to challenge us if it's really absolutely wrong, or we're, somehow we're misinterpreting something really badly. And in the case of, for instance, Clerk of the Board, Angela Calvillo, that in that kind of case, it's gone through many iterations of appointments to the Sunshine Task Force, that interpretation has been held. So if the Ethics Commission then hears this for the first time and says, nope, we see it something different, it subverts over a decade of work and interpretation that has not been challenged ever before. Not to say that it couldn't, but let a court do that and allow the violation, as the task force has found it, as to survive. That's my thought about this.
I think, and Jess, correct me if I'm wrong, but I think the way that you've worded the remedies section would allow the commission to uphold a determination of a violation, but to exercise its discretion not to assess penalties or not to exercise enforcement of other kinds.
Yes, that's right. And it also considers, it was a small thing you said, but something like fine them, I think you might have said into oblivion. I'm not sure what the word was, but I just want to make sure that we'll be responsible with our penalty authority, and we have a requirement that the commission and the staff consider a respondent's ability to pay if it's raised as a issue in response to an assessed fine. And that's because we take the Eighth Amendment seriously, and we don't want to impose fines or penalties on people that would put them in bankruptcy or force them into a debtor's prison type of scenario. So, I think overall it'll be a positive thing. These new regulations and this new process, but I also want to emphasize that we share your same concerns in a lot of regards. And if we can take these out for a test drive over the next year. And just like we did over the last year, for me anyway, because I've only been here for a year, and if something's not working, or if we're still not seeing the results we want, we can go back in and revisit this. And I think that's a fully and meaningful exercise. I share your deep commitment to public trust in open government, and really want this to work. I think the Sunshine Ordinance Task Force itself is a very unique and impressive tool that the Board of Supervisors created, it's the people created by referendum, and we should work hard to make it work, and that is my goal here. That's what I want to do.
Thank you. Can we continue through the document?
Yeah, I'm done, actually. Those are the main points. Those are the main huge changes or changes generally that are contained in the document. So if there are any other questions, I'm happy to answer, and Jeff's there too to answer.
What are the next steps that you're taking as part of the amendment process or editing process of this document?
So we have to publish the regulations 10 days before the commission meeting on December 8th. So our next commission meeting is on December 18th. So we'll have to publish the regulations for the commission to adopt them by December 8th. We can push that to January if this body would like to provide public comment or additional input on what additional changes that needs to be made. But otherwise, we're sort of on our end, we're just working on some last-minute changes that the city attorney's office has asked, some last-minute tweaks, and then a final internal review that's basically for typos and glaring inconsistencies or mistakes. So we're pretty close to the end of the process in terms of public review and public comment, but we would be happy, like we were planning on putting these regulations on the agenda in November for the commission to consider, but we wanted to make sure that we gave the task force time to consider them and give their input. And if you need more time than December 8th, we're happy to give you more time.
So this is Luam Tesfaye. The task force will next be meeting in full in early December, and we would need some time to look at the document and solicit comments from all of our members so that we could appear. Is there any way that you can publish the document on December 8th, but then take it up at your January meeting to help facilitate that process?
So you should consider this document to be something you can circulate to your members and get their public input on. This is a draft that's already been made public to your body. So there's the draft that I have to publish for the commission to consider is the final draft. There can't be any changes made after it.
Okay.
So this is the one you should share.
So what we will be doing probably is, though we will circulate this to our members, if we are going to provide any kind of public comment, we would vote it out at our meeting, and that would require us to have public comment at our meeting. So that wouldn't really give us enough time to edit those public comments and get them in by December 18th. So would you be able to take this up at your January meeting instead to help facilitate that process? I think that we'll also be asking for some counsel from our city attorney.
Yeah,
I'm certain I can do that, but I'll just confirm with the chair that he's okay with that. And but we want to hear and are very interested in your comments. I will say that hopefully your city attorney has been involved. I guess I don't really know what level of involvement the city attorneys have with each other, but the city attorney's office has signed off on the regs.
I believe that our city attorney is walled off from other agencies and other work, so I because of conflict, so I don't believe that he would have been working on this, and he hasn't communicated that to us. I think that, Chair Wolf, would you be willing to work with Ms. Bloom on facilitating us getting this together for January?
Yeah, I would. If you're saying that if you introduce this as the final draft in December and that it cannot be changed until the public hearing in January, until it goes before the Ethics Commission, I kind of find that's a little bit too quick. I mean, we haven't had...
So if we move it to January, we would not publish... So our bylaws that require that we publish final drafts of regulations that the commission will consider 10 days prior to the meeting. So if you don't think you can provide comments by December 8th, then we would not publish it until the January meeting, 10 days prior to the January meeting.
Great. We would prefer that. There's no way that we could meet that deadline.
Okay. It's definitely made complicated by the fact that the commission meeting is a couple weeks earlier because it's a holiday.
Right. We're dealing with 11 members and a active public.
But we can use, since you said this is the version that we can use, we'll just go ahead and start using this version in order to get our comments together.
Right.
Yeah, that'd be great.
Thank you.
I have... I just wanted to go over, if you don't mind.
Yes.
So we're in section 10. B1, Roman numeral 4, deliberations and findings. So I just wondering if, I'm not sure if this is just language or whether this is intent. So I'll just start reading it. The commission will deliberate in public. Public comment on the matter will be allowed at each meeting, each hearing, in accordance with the Sunshine Ordinance and the Brown Act. To determine that a violation of the Sunshine Ordinance occurred, the commission must conclude that, based upon a preponderance of evidence, the respondent committed a violation of the Sunshine Ordinance. So, to determine that a violation occurred, okay, that language I'm concerned about because that sounds like re-adjudication, to make a new determination. Now, I understand, based upon what you mentioned before, that Jeff?
Yeah.
Jeff mentioned before that, each body that has authority and jurisdiction, has the ability to kind of, make proper determinations as to, with regards to what additional authority they may have. So in this case, we're talking about enforcement. I would say that court comes after what happens at the Ethics Commission, not...
Probably traditionally, but I don't know if that's required by law.
No, it's not required, but I think a person will... If they're going through the process of the Sunshine Ordinance, then the next step will be the Ethics Commission.
Gotcha.
If they don't like what the findings from the Ethics Commission and the whole process at the local level, then they'll take it into the judicial branch. Mm-hmm. Or they could just bypass, the local process and go straight to court. Court might say, I'm ordering you to go back and do the local process, or the court might say, okay, take your chances with me, okay? So, but I just want to say that there is a definitive branch difference, governmental branch difference between the courts and what we're doing here. So,
sure.
But be it as it may, getting back to the language here, I'm a little concerned that I guess what I would rather it say, this is what I would like it to say, is that a preponderance that, well, it's kind of like the preponderance of that the violation has occurred. The Sunshine Ordinance Task Force has found a violation, except that the violation has occurred. I don't think that the commissioners will accept that. Considering their kind of experience and their stature, but even though we equally have lawyers and people with experience here, but I'm just a little concerned that speaks more about a re-adjudication, and I'm wondering how that might. I'm not sure whether that was the intent or whether it's just wordsmithing. Or just language?
No, I think that's just wordsmithing, and that's a valuable comment. And I mean, all of your comments are valuable. You don't take that the wrong way, but we can take another look at that language as part of our process here, and try and construct a scenario where it's more of a, because it actually conflicts. This part kind of conflicts with the earlier standard of proof, where it says the respondent will have the burden to prove that he did not commit a violation.
Right.
That's the operative burden of proof, and so I think this somewhat conflicts with that. And so I'll take a stab at drafting some language that would incorporate that burden of proof into our deliberation process.
And just, I think the final sentence in that paragraph kind of speaks to it nicely. The finding that a respondent committed a violation of the Sunshine Ordinance will be supported by findings of fact and conclusions of law and will be based on the entire record of the proceedings. And I think that is really kind of where I'm getting at, that there it could be said that the finding of a respondent committed a violation of the Sunshine Ordinance by the Sunshine Ordinance Task Force. That's kind of what I'm saying in that kind of way. I'm also wondering if just in practice, if there wouldn't be, if we decide to refer a matter to you for enforcement under this rubric, anything other than willful misconduct. I'm wondering if it wouldn't be, since you folks, well, you have it in here that the deliberations will be in public, but will there be any activation of the investigative department to create a brief or to create any specific advice or recommendations to the commission prior to it coming to them? And if so, would it be good to have a process where we meet, like have a conference to make sure that all the facts, that it's understood? I don't know. I'm just wondering if there wouldn't be a meeting of the minds during that handoff. Have a that kind of way.
I don't think that needs to be in the regulations, but I think that us having an open line of communication on issues like that is definitely something that we could start doing, so that you are not surprised if we do draft a memo disagreeing with your legal conclusions, which is the only thing that we would ever do, and the only time I've ever done it is with that Steve Kava matter. But otherwise, we will not be on referrals from your agency to ours unless we have a strong view on the legal issues that differs from yours. We won't be drafting any recommendations to the Ethics Commission, except that we might give them a cover memo that explains this process, instructs them to defer to your findings of fact, and explains how they should assess penalties once they agree with your order of determination. But we're going to try not to involve ourselves in an investigation of your referrals in any way.
No, I understand that. I'm just talking about how you prepare the case for enforcement to the commission, so that way we have an opportunity administratively to make sure that there's, that everything is understood, that you have people like Jeff and other folks on your staff that have, a good experience with this. So there's that's the survivability part that I'm want to kind of be assured of. So that at least administratively, because you have that ability, you have a whole department around investigations and in that kind of way. We don't. We do it all out in the public forum. That if you have a set of a process. Do you follow what I'm saying?
I am. I'm just trying to figure out.
Because I feel like I'm rambling on.
No, well, no, I'm wondering whether, and this is, I guess, a question of historical practice, does the task force appear as a party? The respondent obviously appears because they bear some burden of proving that they were not in violation, but does the task force appear as an interested party seeking to have its order enforced, or does it fall entirely to our commission, Jessica, to represent the task force's position?
We have appeared and given presentations, but not as a party to the proceedings. So, in my mind, I think of this document, if it included some type of dispute resolution process that was outlined, that could give you some peace of mind on this. But at the same time, I don't want to call it dispute resolution because I don't want the idea that the task force is a party to a proceeding to, be out there. So
under the show cause hearing here, 10B1 in 3A, additional briefing not required, we have the language, the parties, plural, the parties may but are not required to submit written evidence and argument. And Bruce, your question was about briefing. So the discretionary word may is used there. I hear you asking whether the commission is a or maybe the investigative unit of the commission is the relevant party standing in for the task force here, and whether the investigative unit would exercise its discretion to brief.
That's an interesting thought. I do want to also respect what Chair Tesfaye just said, that the task force shouldn't be regarded as a party.
I would also see the investigative unit as serving in an advisory role to the Ethics Commission, not in, or do you serve as an active party yourself?
That's what I'm wondering.
Not on these. So not on referrals. We would be an active party in the other kinds of investigations where we're handling them ourselves because we're basically the prosecutors. But under referrals, right now and going forward, we would just be advisors. So the way it works now, and this is not something that I want to change. I want it to be a straight shot. You have from your order of determination to the Ethics Commission with nothing interfering or getting in the way. So it's supposed to happen at the very next commission meeting unless that's less than 15 days for notice reasons. So once you have an order of determination, you refer it to us. We'll put it on the next commission meeting agenda. And then if the parties, the petitioner and respondent, want to submit additional briefing or writing, they can, but they don't have to. And then they would go before the commission themselves, and the staff would not have a role other than to explain the process to the commission and make sure that they understand they need to defer to the order's findings of facts. They have the option to remand and all these other different things that I'm adding in here.
So yeah, in that case, they would be serving in an advisory capacity, and I wouldn't feel comfortable with us getting too involved in that unless we had some type of MOU for intercommission coordination, something like that in place, and then the MOU could outline what that process is. But if someone like Mr. Pierce is serving in an attorney advisory capacity to the commission, it wouldn't be appropriate for us to get involved in that attorney-client relationship or work product relationship.
I think that's right. I think that you could still come to commission meetings if you felt an issue is particularly important and give presentations on those subjects. But otherwise, I think that if there are disputes that arise, I think what you're basically asking for, Chair Wolf, is Member Tesfaye, regarding your idea of dispute resolution process, which I agree can be outlined in a memorandum of understanding. You're basically asking for, a way for us to reach an agreement in a non-public and non-dismissive way on an interpretation of the law.
More of a coordination, because dispute resolution would make it seem like we are some type of an active party, right. and an MOU for something like that, which occurs in many state agencies, different commissions, would be something more of a coordination document, a process that outlines a way for the Ethics Commission to coordinate with the Sunshine Ordinance Task Force in this type of event. And the process would be laid out so that all of the expectations would be clear. But I wouldn't want to call it dispute resolution because it implies certain things about who we are and who you are in our relationship with each other.
Let's talk about it in more functional terms. It's kind of like the process of handing it off. It's not like we just send it over like we have been. It would be more like, there'd be a coming together. There would be some discussion about the results. You would have, if you had any questions about how we came to those conclusions, so you can have a little more full understanding of how we came to that conclusion. If it's not clear either through the audio recordings or in the minutes, in that kind of way, it's kind of like it's a process. It comes to us first for adjudication to find determination, and then it moves to the next process for enforcement. I would not characterize it as the primary court and then the appellate court. I wouldn't do that because the primary court can actually issue enforcement and penalties. We can't. So this is kind of like part one, and then if we determine that it was egregious enough that in a certain kind of enforcement where certain enforcement should be instituted, then we would activate the next part, and that the next part, the process for the next part of that handing off would be some sort of kind of like you said, coordination, or I like to call it a conference, so that way you accept it with anything that we might want to highlight to you as to how we came to those conclusions, or any questions that you may have for us to clarify for that. That way, I go back to the point of survivability of the work that we've done, so that it doesn't seem like, go on.
Well, I'm going to have to think about that a little bit more, because it feels a little bit like, maybe this is just my reaction right now, and I'm not sure if I'll stick with this, but I think it feels a little bit like you would be meeting with staff to sort of explain yourselves, which I think is a wonderful thing to do. I think that should happen, but then you don't want to appear at the Ethics Commission's meeting, and so staff would be sort of standing in the shoes for what the task force was trying to say in its order, because we don't now say anything to the Ethics Commission. It's just a pass-through order. So I need to think about more about the most appropriate way to affect what I hear is a very real concern and something we need to address that doesn't require us to sort of be an advocate for the task force, because that would be unfair to the parties who are actually before the commission, to whom we're legal advisors in an enforcement proceeding.
Okay, so then let's go to the. There was a section here that talked about the process. Where does it say there was a time? There was like a time. Where was that? Show course. It said something like the Sunshine Task Force. Well, here in B13. Hearing procedures. Upon request, a representative of the Sunshine Task Force, a complainant, and respondent will have each have 5 minutes to present their arguments to the commission during the show cause hearing.
Yeah, that was where I was trying to give you the opportunity I think you're talking about to explain your decision and say why you think it's right, without staff having to stand in those shoes, because we haven't done the investigation, and so unless I go back to Kava, where the issue was so confused and the law was I didn't even think the city attorney's office got the law right on that. I intervened in order to explain my view of what the law was.
Okay.
But otherwise I'm not going to get involved in your findings of fact or even your conclusions of law, like with the Angela Calvillo one. I agreed that could go either way. I was like Paul Rennie. It could go either way. And so I just said, that's up to the commission then. It's not going to be a staff issue.
All right. So maybe I'm overthinking this a little bit, because I guess I was thinking that in the regular course of ethics process that the investigative department would be involved. If the investigative department is not being, or any other staff is, let's just call it staff. If staff is not going to be involved in providing direct, either legal recommendation or advice to the commission on this, and it'll just be all deliberated by the commission themselves in public, that's a different story, okay? If that's the case, then I would not have the Sunshine Task Force be placed in a status that is equal to the complainant and the respondent. I'd like to find some other way, because we're part of this process. We're the ones that are sending it for enforcement. We're not party. We're, this is like just part of the process. If we had it, imagine it just for the Ethics Commission for itself. Okay, if the investigative division found a violation, they brought it to the commission. The commission agreed and approved that there was a violation, and then it goes for enforcement. does the enforcement part of it then challenge the original finding of the commission? I mean, does enforcement then say no? We don't see that there's not a violation. I mean, it's kind of like that, and so it's. But I just want to find a way if there is not going to be any kind of administrative coordination for this, and it's just going to goes directly to a public hearing, then I'd like to find for some other compartment for the Sunshine Task Force to be able to present its case, or be able to. Not even, I don't know that we even have to, prove ourselves. This is just our finding. I don't know.
You just might want to lobby them sometimes. That's really what it is. You just might want to have an opportunity to lobby them. I mean, for lack of a better term, lobbying is a regulated activity, and so it's not exactly what you're doing, but I understand. That's why I wanted to give you some time here. We can move that sentence around so that it's not lumping you in with the complainant and respondent for sure.
I'm almost.
That's the general idea.
I'm almost of the thought, and I'm just thinking, freely associating, thinking outside the box, that that the actual handoff is actually a hearing, and that it doesn't involve the parties. It just involves the Sunshine Task Force showing up to the Ethics Commission and saying, we have found a violation. We are providing it to you for enforcement. The Ethics Commission would have some time prior to, that coming, so it could be reviewed. They understand what it is, and they can ask us any questions with regards to how did you come to that conclusion, so on and so forth. They have a conversation with the Sunshine Task Force and not actually adjudicating the case at the time. They're kind of doing their own investigation, or what you call show cause, in public also, but with us, just to make sure that they understand what it is or isn't. If it comes, because if it comes to a point where there may be a conflict, because if you just draw a bright line and the Ethics Commission has the ability to overturn or disagree with our finding, then this might be an opportunity for them to say, you know what, we have a little bit of a different understanding about this particular part. The task force can reconsider it, bring it back, have further discussion. Maybe we missed something, or maybe something that we need to further clarify so that it makes it more clear for the Ethics Commission in order to move forward with enforcement in that kind of way. You follow me?
My reaction is I don't think our commission would ever agree to have 2 hearings on every referral. I just don't think that that's going to be in the cards. What we could do is Bruce, you always have this option, and if you are concerned or you feel strongly about a referral or an interpretation of the law, you can call the chair and discuss it with him. And I think that would be entirely appropriate and welcomed by the current chair, and definitely by the next chair too. The next chair will be Dana Chu. They both would welcome that kind of collaboration with you. But I don't think that our commission would ever agree to have 2 hearings on every referral.
Okay. Well, okay. I'm more concerned. I'm more interested in the process than I am in the function, whether this whether they'll do two hearings or not. I just want to see if we can find a way. If you think the best way to do it is to have somewhat of a, bless you, kind of a private meeting, to have discussion with the chair on this. Yeah, I think I'm open to that as long as the chair will in future will continue to be open to that. I think I'm a little more interested in a process so that there's some guarantee, and that in case things become political in the future, that any conversation could not be not happen. So I don't know. Like I said, I'm freely associating on this right now. I'm just thinking outside the box, but that's kind of what I'm thinking.
And that could be one sentence added to a document like this. It wouldn't necessarily have to be an MOU, but like one sentence where it states, the chair of the Ethics Commission or the chair of the Sunshine Ordinance Task Force may confer with the chair of the Ethics Commission concerning referrals as they appear before the Ethics Commission or something like that. So then it's just, you have a sentence there, something to refer to that this is something that should happen.
And would that be a violation of the Brown Act?
No.
It's not a quorum of
right.
commissioners
Either
on the same
body.
commission meeting, and you're also not a party, so I don't know if I would consider that an ex parte contact. I don't know.
Well, okay, then I'm thinking.
No, I don't think it would be a violation of the Brown Act.
What about ex parte?
I don't know. Does the Ethics Commission have ex parte rules, or?
I don't know. Do they?
We do. We follow the ex parte rules, yes, of the California Administrative Procedure Act, but that only applies to parties. You're right, Bruce, that this is a unique scenario where one body is conducting the fact-finding and then another body is enforcing the law. And that creates a unique situation, especially when, I don't think anybody wants the Ethics Commission to re-adjudicate or re-litigate the facts. And so my solution to this was to give you, even though it's more work for your group, you an opportunity on cases where you feel like it's important to have some time to speak to the Ethics Commission. And I think that perhaps we can do both things. We can do what Member Tesla suggests and say that you can confer about a particular matter at any time. And then we can also suggest that in the regulations that if a representative of the Sunshine Ordinance Task Force wants to speak on a particular matter, that they be given an opportunity to do so before the show cause hearing starts. I think that might be a better solution than have you speaking during the show cause hearing.
I hear you. I had another idea, that maybe there could be some process within the Sunshine Task Force to determine whether there would be any issues with enforcement. Like, I don't know whether there's enough information in the Ethics Commission side for us to be able to do like provide a test. So that would go to like our Compliance and Amendments Committee, before, so there'd be a request for referral, or the task force would, have an order to refer it to ethics for enforcement. But before it does that, it goes to Compliance and Amendments to test to see if there's anything that might be missing, or something doesn't rise to an occasion, or something like that, so that we could be assured that when it gets sent over to ethics, we have some assurance that we've kind of covered all the bases. I don't know.
Yeah, I think you'll probably, going forward, I think as we work through this new process, we'll definitely find some areas where a memorandum of understanding might be helpful. We'll find some areas where both of us need to reevaluate our internal procedures or the level of communication we have with each other, because I'm basically giving each of our bodies what hopefully will be more authority and strengthening the ability of both bodies to do their jobs in a way that compels respondents to listen and pay attention. So repeat offenders are fined, and or even one-time offenders, if for egregious or even just regular routine violations that should be known.
Mm-hmm. Okay. Yeah, I think the overall
there
goal.
was a time I tried to enforce the law actually, but the respondent the plaintiff withdrew. I had it all teed up for my commission to enforce the law. So, another thing I guess I forgot to mention, in order to encourage the public to send their complaints to the Sunshine Ordinance Task Force, I state in the regulations that we will refer all complaints to you unless they involve willful violations involving department heads or elected officials. I should have mentioned that earlier, but it's not in Section 10. It's in the handling of complaints part, Section 3. And then page 3. So Section 3E, it states, if a complaint filed with our commission does not meet the criteria set forth in Section 6734, we will refer it to the task force. So we won't. There's been some occasions in the past where our body has handled the investigation of complaints that were filed with us that didn't allege willful violations by department heads, and I don't want to do that anymore. I want your body to handle all complaints so that the public knows where they need to go.
That's fantastic.
Just one quick question about ex parte. There is a provision in the existing regulations, the existing Sunshine Ordinance regulations. It's Chapter 4, Section 1A, but it says once a complaint is filed with the commission, and then it sets forth the prohibition on ex parte communications. Do we interpret that to mean only original complaints as opposed to referrals? I know that this hasn't been transported into the other regulations, but if it exists in the administrative procedure, then we can't really undo it merely by omitting it in the new version.
Yeah, in the new version, in the new regs, it states that once an investigation is opened and until the commission has made a final decision. So these are not open investigations, these are referrals. So the ex parte communication rules would apply in a limited sense. Like we wouldn't want a respondent to be privately communicating with the chair, but I don't think that the two chairs conferring would be a problem.
Are there any other comments?
Nope.
Okay. With that, I think we should close this item.
Okay. Thank you, Jessica and Jeff. I really I think we all appreciate the work on this and your thoughts and thinking of us in the process. To me, it's extremely exciting in the, dozen years that I've been doing this, that something like this has never been thought of in this kind of way. So really appreciate your innovation and interest. Thank you.
Thank you, and Chair Wolf, if I can, I'll just check in with our chair and get back with you within the week about your request to push to January, which I'm certain will be approved. But just so that I can close the loop on that with you.
Great, thank you. And Jeff, thank you for coming up there.
Please let me know if you want us to appear at the December task force meeting before the full task force.
I think that would be good if you did, just to field any other questions, and
okay.
we'll try to prepare them ahead of time. I think maybe what we could do is do a little write up and put it into the agenda based upon this meeting, as part of or actually include the minutes of this meeting. And with a link to the audio so people can listen to it before the full task force meeting. Try to get them to be prepared as much as possible.
Yeah, that sounds good.
Thank you.
Okay, well, thanks very much for your time.
Thank you, and feel better.
Thank you. Bye.
So it's my understanding you would like to refer this matter to the December 6th meeting of the Sunshine Ordinance Task Force.
Yes.
Yes, please, with a link to the minutes from this meeting and the audio recording.
I believe the audio will be more will
Yeah.
be more relevant, as the minutes won't say very much on the details.
Thank you.
Right. And I'll if you don't mind, I'll write. You want to write up a note? I'll write.
can't,
I'll
yeah.
do it.
Thank you.
I'll write up a memo to be included with the minutes. I mean, with the agenda for this item.
Yes.
Thank you.
And just to note, DC Acola will not be in attendance at the December 6th meeting.
Okay. Well, also, we should refer this to him also. Let's make sure that he has a copy of this and
Yes.
that, and let him know that I'll contact him
Yes, I will.
to fill in the blanks for him.
Yeah, perhaps he could provide something in writing.
Yeah.
If he can't be there in person. So,
Right. Okay.
Would you like to make that motion to refer?
Yeah, I'll move to refer.
thank you. Can we take that by acclamation, or is there public comment on that motion? Seeing none, can we take that by acclamation, please?
That motion is adopted without objection.
Thank you.
Next on the agenda is item number 7, announcements, comments, questions, and future agenda items.
I don't have any other members. No. Okay.
No.
Okay.
I move to adjourn.
Do you have a second for that? Thank you.
The meeting is adjourned.
Thank you. Thank you, guys. Thank you, guys.